So, with your permission, shall we please start the session?
Absolutely.
All right, so a very warm evening to all the attendees presented over here. We, the team Legal Expatiate, feel privileged to welcome you all to our 7-day online course on Art of Drafting Civil Matters. It is a great honor to be here today to introduce a distinguished professional advocate Nagesh Sood sir, whose career has been marked by dedication, expertise, and a profound commitment to justice. Honorable Sir completed a BSc Honours in Physics from Delhi University in 1990, followed by an LLB from Aligarh Muslim University in 1993 and an LLM in Environmental Law from Gujarat University in 2010. Adding to these impressive qualifications, Honorable Sir also undertook a postgraduate program in human rights from the Indian Institute of Human Rights in New Delhi. With a legal career spanning over 30 years, Honorable Sir has made significant contribution to the field of law. Beginning as an advocate in 1993, they have served as an additional public prosecutor and assistant government pleader in High Court of Gujarat from 2003 to 2005. Throughout this period, Mr. Sood has gained a wealth of experience in banking and insurance cases as well as service and labor matters. Honorable Sir has served on panels of numerous prestigious institutions, including Central Bank of India, Union Bank of India, IFCI Limited, Indian Bank, National Insurance Company Limited, New India Insurance Company Limited, Bank of Baroda, Gramin Bank, Kotak Mahindra Bank, Bank of India, and UCO Bank. Among their professional achievement, he has successfully pursued public interest litigations, defended crucial legal issues, and contributed to landmark judgment in various high courts. His work has not only earned him recognition but also numerous reported judgments in law reports. In addition to his legal practice, Honorable Sir is a visiting faculty member at Nirma University, Karnavati University, and Gujarat Law Society, imparting knowledge in corporate litigation and advocacy. They are also deeply involved in social causes, working with NGOs like SATH for suicide prevention and providing free legal aid through the Gujarat State Legal Service Authority. Honorable Sir's contribution extend to the international stage as well, serving as a trustee and director of Befrienders Worldwide, a UK-based organization with 371 suicide prevention centers globally. Furthermore, he is actively involved in a Teach India campaign offering basic education to underprivileged children. With that, on a personal note, on advocates Nagesh Sood sir from a family dedicated to public service with a father who was a group commandant in CISF and a younger brother who is a colonial in our Indian Army and the recipient of Shaurya Chakra. It is clear that Honorable Sir is not just a legal luminary but also a compassionate individual committed to making a positive impact in the society. We are privileged to have you with us today. Please join me, everyone, in welcoming Honorable Advocate Nagesh Sood sir for today's session. We heartily welcome you, sir. And with respect, I would now request you to kindly take over this session and enlighten us all.
Thank you very much, ma'am, for a very overwhelming introduction. I'm honored to be here. And today, the topic which is assigned to me is about drafting of a couple of petitions, namely execution petition, revision, review, and writ petition, and public interest litigation. So I'll begin with an overview of these proceedings, how and what are these proceedings which are filed before the various courts. And coupled with that, I will also talk about what includes the drafting of these petitions. So, first of all, let's talk about the execution petition. Now, what is an execution? Execution is the process of enforcing a decree passed by a competent court in favor of the decree holder. It is not explicitly defined in the Code of Civil Procedure, but it refers to implementing court judgments to ensure that determined rights and obligations are fulfilled. So, this is about execution petition. An execution petition is a formal request to the court for the execution of a decree, order, as defined in Rule 2E of the Civil Rules of Practice. Kindly have page 2. Next slide, please. So, what is the jurisdiction under which the execution is filed? Under Section 37 of the CPC, the court that had passed the decree has jurisdiction to execute it. Section 38 of CPC allows the court to which the decree is transferred to also entertain an execution petition. The execution court cannot go behind the decree or examine its correctness. So whatever the competent court has decided, has given a judgment or a decree, the executing court does not have any power to examine its correctness. It cannot go behind what has been decided by the court. It can review although the pleadings and proceedings to understand the trial court's intention. If the decree is nullity or the trial court lacked jurisdiction, execution can be refused, as has been held by the judgments which you can see on the slide. If there is a conflict between the judgment and the decree, the execution court can look into the judgment to understand the court's intention. So finally, the court can find out as to what the intention of the court has been through the decree or the judgment, and can thereafter execute the same. Next slide, please.
Sir, is the next slide visible?
It is not.
Sir, from my side, actually, I am changing the slides, but I don't know what's the issue.
Now you have to change the next slide, please. Slide number 4.
Just a second, sir.
On full screen.
Now is it visible?
Yes, it is visible, but make it visible on full screen.
Sir, now is it visible?
It is visible. You can make it.
Yes, I have made it to view on the big screen, but it is not actually getting it shared.
You have to press
some technical
F5. You
glitch.
have to press F5.
Sir, actually, I have pressed it, but
Or
it's not getting.
so what if a decree has to be transferred to another court? The transfer of decree involves moving a decree from one court to another for execution. Section 39 of the CPC and Order 21, Rule 5 and 6 govern the procedure for transferring decrees Section 39(4) specifies that a decree cannot be executed if the person or property is outside the court's jurisdiction. Now, the example is Debt Recovery Tribunal under Section 1923 of the Recovery of Debt Due to Banks and Financial Institutions empowers the DRT to transfer cases to ensure efficient resolution. Section 20 of the said Act also allows for appeals to the Debt Recovery Tribunal, ensuring oversight and the ability to stay executions if necessary. The Honorable High Court, also under Article 227 of the Constitution of India, provides for supervisory jurisdiction over all courts and tribunals within its territory, including the power to transfer and stay the proceedings. So the power of transferee court, where the decree is transferred, is defined under Section 42 of the CPC, which governs the power of the transferee court. The civil rules of practice details the forms and proceedings to be followed in cases of Maradia Chemicals Limited versus Union of India, reported in 2004 for Supreme Court cases 311, wherein it has been upheld the constitutionality of the DRT Act, ensuring that decrees can be effectively transferred to and executed by DRTs. Order 21, Rule 26 allows for a limited stay to enable the judgment debtor to obtain necessary stay orders from the trial court. Order 21, Rule 29 provides for a stay of execution under particular circumstances. So whenever there is an execution which is passed against a person, which is called a judgment debtor, the judgment debtor can approach various courts, the appellate courts, to get the stay order on said execution. The cases I'm referring here is of Kishori Lal versus Chairman Employee State Insurance Corporation, reported in 2007 for SEC 579, which discussed the role of lower courts in transferring cases and staying executions. Also, Nahar Industrial Enterprises Limited versus Hong Kong and Shanghai Bank Corporation, reported in 2009, 8 SEC, page 646, addressed the interplay between the civil courts and tribunals in decree execution, including the stay orders. Next, please. What are the kind of decrees we have? One is simple money suit decree, a decree where a sum of money is payable. That is simple money suit decree. Under Order 21, Rule 1 and 2 of the Code of Civil Procedure Code specifies methods of payment, including by installments, direct payment to the decree holder, or through the court. Page 5, please. The previous one. So these are the kind of decrees. Order 21, Rule 30, money decrees can be executed by attachment and sale of the judgment debtor's property, by arrest and detention in prison, or other suitable means. I will deal with that in the next slide. Executed by arrest or the judgment debtor in DRT, subject to certain exemptions and procedural requirements. In the case of Kancheria Lakshman Narayanan versus Matapati Shamla, reported in 2008-9 Supreme Court cases 258, it is clarified by the court that the methods of execution and rights of decree holder are so and so. Mortgage decree is also a kind of decree which involves the enforcement of a mortgage, typically resulting in the sale of the mortgage property to satisfy the debt. It is executed by attachment and sale of the mortgage property. Order 34 of the Code of Civil Procedure 1908 deals with suits relating to mortgages of immovable property. Section 67 of the Transfer of Property Act 1882, the mortgagee's right to sale are defined. In the case of State Bank of India versus SBS Farmer Service Society Limited, reported in 1995 Supreme Court cases, page 50, discussed the execution of mortgage decrees and the sale of mortgage property. The next one is the maintenance decree, which is a decree ordering the payment of maintenance to a spouse, children, or other dependent, which is generally passed by the family court. It is specific provision applied for the execution of maintenance decrees. Section 125 of the Code of Criminal Procedure, 1973, provides for the maintenance orders and their enforcement. Order 21, Rule 48 of the Code of Civil Procedure, there could be an attachment of salary for maintenance. In the case of Daniel Latifi versus Union of India, reported in 2001, 7 Supreme Court cases, page 740, it was highlighted the right to maintenance under personal laws and the enforceability of such decrees. Now, what is the limitation which is provided under execution? Article 136 of the Limitation Act 1963 provides a 12-year period for the execution of any decree or order of any civil court. Decrees against the government have a 3-month waiting period before execution. Section 48 of the Code of Civil Procedure initially provided a limitation period, now replaced by the limitation. In the case of P.S. Sada Sivaswamy versus State of Tamil Nadu, reported in 1975, 1 SEC 152 emphasized the importance of adhering to limitation periods in executing decrees. In the case of SP Chengalavaraya Naidu versus Jagannath, reported in 1994, 1 SEC 1, in this the court discusses the scope of execution proceedings and emphasizes that the executing court cannot go beyond the decree. It also highlights that the decree holder must ensure that the decree is executable and must provide accurate information to the court. Next slide, please. Now, what are the mode of execution? Number 1 is the arrest. Under the Code of Civil Procedure, Section 51B, this section grants the authority to order the arrest and detention of a judgment debtor to enforce a decree for the payment of money. Order 21, Rule 37 provides for the procedure for arrest and detention of the judgment debtor. There is an exception wherein women and certain classes are exempt from arrest in execution of money decrees. Section 52 to 56 of CPC, there are steps before ordering detention include issuing notices and conducting means inquiries. In the case of KK Verma versus Union of India, reported in AIR 74 Supreme Court 549, in that case, as to what are the legal standards and conditions under which arrest can be made in execution of a decree. The next mode of execution is attachment. Under Section 60 of the CPC, it specifies the types of property that can be attached and those properties which are exempt from the attachment. Order 21, Rule 43 to 45 deals with the procedures for attachment of property, including the attachment of immovable and movable property. There are exceptions. The process of legally seizing property to satisfy a judgment, certain properties are exempt from attachment under Section 61C of CPC. In the case of KK Verma versus Union of India, reported in AIR 1974 Supreme Court, page 549, the case addresses the attachment related to issues within the context of civil procedure. The next mode is sale. Under Order 21, Rules 64 to 69 deals with the procedure for the sale of attached property, including the sale of immovable and movable property. There is an exception. Under the small causes courts cannot sell the property. Original courts can. The sale process must follow specific legal procedure to ensure the fairness and maximize recovery. In the case of AC Arulapan versus State of Tamil Nadu, reported in AIR 1997, Supreme Court 1465, the court addresses the issues related to the sale of property in execution proceedings. Next slide, please. Now, what is and how drafting of an execution petition is done? What are the key components? What are the tips of drafting? And what are the don'ts of drafting? The key components include the title, the jurisdiction, party details, case information, nature of decree, grounds for execution, relief sought, supporting documents, verification, and prayer. What are the tips? One has to be precise and concise, follow legal requirements, attach all relevant documents, double check the details, and use clear language. Clearly identify the decree. In the case of SP Chengalavaraya Naidu versus Jagannath, the Supreme Court held that an executing court cannot go beyond the decree and must enforce it as it stands. So whatever the decree is, whatever the executing court has power only to execute what is held by the court in the decree. The executing court does not have power to go behind the decree and forms its own opinion to execute something which is not there or what is not spelt in the decree. So the decree and must be enforced as it is, as it stands. By properly identifying the decree, it ensures that the execution is in accordance with the court's directions. What is the state? What is the relief which is sought to be stated? In the case of MC Chokilagam versus State Bank of India, reported in AIR 2008 Supreme Court, page 1252, the case highlights the necessity of specifying the exact relief sought. The court emphasized that the execution petition must clearly articulate the relief to be granted. So, whatever the relief you want from the court has to be clearly mentioned in the execution petition. Follow the procedural requirements. In the case of MS Venkatraman versus State Bank of India, reported in 2005, 1 SEC 2011, the court has emphasized the importance of following procedural norms for the successful enforcement of decrees. Provide full details of the judgment data. In the case of Vishwanath versus Keshav, reported in AIR 1961, Supreme Court 79T, this case underscores the importance of providing complete details about the judgment data to facilitate effective execution. So the details of judgment data is a must, not only what is mentioned in the decree, in the title, but something more than that, so that the notice by the execution court can be conveniently sent to the judgment debtor and judgment debtor can appear before the court. Attach the supporting documents. In case of Harnam Singh versus Union of India, reported in AIR 1991 Supreme Court 234, the Supreme Court noted that a petition should be supported by appropriate documents. The absence of proper documentation can lead to the dismissal of the petition. So whatever documents along with the decree is required to be attached must be attached with the execution petition. What are the don'ts of drafting? Avoid omitting essential information, ambiguity, ignoring jurisdictional issues, exaggerating facts, and delays in filing. Don't omit key details. In MC Chokalingam versus State Bank of India, the court has stressed that petition lacking detailed information about the decree and the judgment data might be deemed insufficient and could be rejected. Don't use ambiguous language. In the case of Chinnamuthu versus Muthuswamy, reported in AIR 1955 Supreme Court 281, the Supreme Court highlighted that ambiguous petitions could cause confusion and hinder the execution process. Precision in language is essential for clear understanding and effective action. Don't fail to authenticate documents. In the case of Arnam Singh versus Union of India, the case underscores the importance of proper documentation and authentication. Inadequate or unauthenticated documents can undermine the petition's validity. Don't neglect filing and service procedures. This case, that is Srimati Kamala Devi versus Union of India, highlights the consequence of neglecting proper filing and service procedures, which can impact the execution process. Don't fail to specify the relief sought clearly. Your relief has to be clearly mentioned in the petition. In the case of SP Chengalavaraya Naidu versus Jagannath, the Supreme Court emphasized that the execution petition must clearly state the relief sought. Vague or unspecified request can result in complications and ineffective enforcement. Next slide, please. Here is a sample of an execution petition wherein from the top, if we start, you have to name the court, that is in the District Court of Ahmedabad, then execution petition number dash of so-and-so year, name of the decree holder, address, occupation, then the name of the judgment debtor versus name of the judgment debtor, address, occupation. Now you have to also mention the age, the current age, what is specified, the whether the judgment debtor is a male or a female. Then we start with the court by addressing the court to the Honorable District Judge. The humble petition of the petitioner is above named is as follows. There is a format wherein we use most respectfully showed that then the petitioner is the decree holder in the above mentioned suit and the judgment debtor is so and so. Then the decree holder dated, decree order dated was passed by Honorable Court in favor of the petitioner and against the judgment debtor. So this is what you have to mention. Then details of the decree. The decree order dated so-and-so was passed by the Honorable Court in case number so-and-so. The decree order directs the judgment debtor. You have to mention briefly as to what is the relief which is granted, what is the obligation the judgment debtor has as per the decree. Then the amount awarded in favor of the petitioner is so-and-so. What is the amount along with interest, rate, what is the rate of interest that is granted by the court per annum from the date of decree until realization. Then comes the grounds. The judgment debtor has failed to comply with the terms of decree order despite the lapse of specified period for compliance. Usually, the court defines as to what is the period in which the judgment debtor has to comply or adhere to the decree which is passed against him. If not, the said compliance is not done, then the execution petition is filed before the court, before the same court, so that the judgment debtor complies with the terms of the decree. Also, we mentioned all legal remedies available to the judgment debtor against the decree holder have been exhausted and the decree has remained unenforceable. So whatever has been the methods which a decree holder can have to get the decree executed has been exhausted, and this is the last mode wherein we can sought for execution of the decree holder. Then comes what are the reliefs. So in view of the above facts, the petitioner respectfully prays for the following reliefs: issue a warrant for attachment and sale of movable, immovable properties of the judgment debtor, direct the judgment debtor to pay the amount along with interest and awarded in the decree, pass any other order that this honorable court may deem fit and proper in the circumstances. So this is the format of the execution petition. Then comes the verification. Name of the petitioner: do hereby verify the contents of paragraph are true and correct to my knowledge and belief. There is a format of verification, and then whatever documents you want to attach with the execution has to be mentioned as supporting documents, like Annexure 1, certified copy of the decree, order dated so-and-so, second, copies of correspondence between the petitioner and judgment debtor regarding the compliance with the decree. There could be the communication between the decree holder and the judgment debtor, wherein the decree holder must have requested the judgment debtor to comply with the decree. So those communications can also be attached. Next slide, please. Now, what is a review petition under the Indian law? A review is a judicial re-examination of a case by same court that has passed the original judgment or order. This mechanism allows courts to correct errors apparent on the face of record, ensuring effective delivery of justice. The power of review is granted to the Supreme Court under Article 137 of the Constitution of India, subject to rules made under Article 145 and laws enacted by Parliament. For other courts, Section 114 of the Code of Civil Procedure provides the basis for review petitions. Now, briefly, I will state as to what is Article 137. The Supreme Court shall have the power to review any judgment pronounced or order made by it. The scope of review is limited as to the next slide, please. The scope of review is limited to errors apparent on the face of record, discovery of new evidence not available at the time of judgment, any other sufficient reason as decided by the court. What is the procedure to file a review? It must be filed within 30 days from the date of the judgment or order as per Supreme Court rules. Generally, petition is heard by the same bench that has passed the original decision. In the case of SP Chengalavaria Naidu versus Jagannath, reported in 1994, 1 SEC, the Supreme Court clarified that review is not a rehearing of the case, but a mechanism to correct errors apparent on the face of record. Next slide, please. Under Section 114, subject to the provisions of order, verify, a court may review its judgment or order if it is of the opinion that there is a mistake or error apparent on the record. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, or by a decree or order from which no appeal is allowed, or by a decision on a reference under Section 18 of the Land Acquisition Act 1894, may apply for a review of judgment to the court which has passed the decree or made the order. Now, what is the scope of review? Review petitions under CPC are limited to errors apparent on the face of record, discovery of new and important matter or evidence, any other sufficient reason. The procedure must be filed within 30 days of the judgment or order, must be presented to the same court that has passed the original decree or order. The petition should clearly state the grounds for the review. Next slide, please. So under section 362, it is provided that save as otherwise provided by this code or by any other law for the time being enforced, no court, when it has signed its judgment, shall alter or review the same except to correct a clerical or arithmetical error. The scope of the review power under section 362 is very limited to correcting clerical or arithmetical errors. It does not allow for a review of the merits of the case. In the case of State of West Bengal versus Shivananda Pathak, reported in 1998, 5 SSC 513, the court held that section 362 does not permit a review of judgments on merit, but only allows for correction of clerical or arithmetical errors. This is section 362 of Code of Criminal Procedure. Specific statutory provisions under Consumer Protection Act 2019 provides for review petitions against orders of the National Consumer Dispute Redressal Commission under section 41. In Arbitration and Conciliation Act 1996 also allows for review of arbitral awards under section 34 under certain conditions. What are the key components? Next slide, please. Of review petition. First is title and jurisdiction. One has to clearly state the title of the petition and jurisdiction of the court. Case information. Mention the case number, date of judgment, and brief summary of the judgment and order being reviewed. Also, thereafter, you mention grounds of review. Detail these specific grounds for seeking the review, such as errors apparent on the face of record. Then, relief sought, clearly state the relief or corrective actions requested from the court. And then verification. Verify the accuracy and truthfulness of the petition. There is a verification format wherein you have to verify that whatever is stated is true to the best of my knowledge and belief. So that verification is important in every petition. Some of the tips for drafting a review petition are: be precise and concise, clearly state the grounds for review without unnecessary elaboration. In the case of Moran Mar Basilius Cathalis versus Most Rev. Mar Polus Athalis, reported in 1954, AIR 526 SC, the emphasis was given to the need of precision in stating grounds for review. Follow legal requirements, ensure compliance with the procedure requirements under the law. The case law also emphasized that adherence to procedural requirements for review petitions has to be done. Attach all relevant documents, include the original judgment, new evidence, and other relevant materials to support the grounds for review. Double check the details, ensure all facts, citations, and procedural aspects are accurate and complete. Next slide, please. Highlight errors or new evidence. Focus on error apparent on the face of record or new evidence that has come to light. In the case of Lily Thomas versus Union of India, reported in 2006 Supreme Court cases 224, the Honorable Apex Court discussed the power to review its judgment under Article 137. Also cite relevant legal provisions and case laws. Article 137 of the Constitution empowers the Supreme Court to review Section 114 CPC provides for review of judgment by the court that passed the decree or made the order. Ensure proper formatting. Follow the court guidelines for formatting legal documents. Use clear and simple language. Avoid legal jargon and ensure the petition is understandable. So your language has to be very simple and understandable to the court. One need not be using a very flowery or difficult language while drafting the petition. And what is important and what is necessary is use a very simple language so that any layman could understand as to what is being said in that petition. What are the don'ts? Don't reiterate arguments from the original petition. Repeating the same arguments already considered by the court does not provide new grounds for review. So there are absolute certain grounds under which a review petition can be filed. So whatever grounds you had taken in the original case need not be mentioned in the petition for review, because that would not be necessary in considering the review petition, because the scope of the review petition is very limited. In the case of Inderchand Jain versus Motilal, reported in 2009, 14 SEC, page 663, the Supreme Court emphasized that a review petition should not be used to re-argue points already decided. Then don't introduce new grounds not raised before. The review is for error apparent on the record, not for introducing new issues. In the case of State of Haryana versus Mohinder Singh, reported in 2004, 3 SEC 392, in that case, the court highlighted that a review petition cannot be used to raise new grounds not precisely argued. Don't ignore procedural requirements. Failure to comply with procedural rules can result in dismissal. In the case of Sasi versus Arvindakshan Nair, reported in 2017, 4 SEC, page 692, the Supreme Court dismissed the review petition for not following procedural norms. Don't submit without supporting evidence. Don't submit your review petition and ensure all claims are supported by appropriate evidence. In Kamlesh Verma versus Mayawati, reported in 2013, 8 SEC, page 320, the court stressed the need for substantive evidence to support the grounds for review. Now, this is the format. It is the same format as I have already discussed in the High Court of Gujarat at Ahmedabad. Then the same format is to be followed as to what are the facts, what are the grounds, what is the error apparent on record. If there is a discovery of new evidence, you have to mention that, and then have a prayer clause and then the verification clause. Now, what is a revision petition under the Indian law? Revision refers to the supervisory jurisdiction of a higher court to examine proceedings in subordinate courts and correct the jurisdictional errors, irregularities, or illegalities. Revision refers to the re-examination of a case by a higher court aimed at correcting errors of jurisdiction, procedural irregularities, or gross injustice in the lower court's decision. This process ensures effective justice delivery and that subordinate courts operate within their lawful authority. The legal framework for revision is primarily established by Section 115 of the Code of Civil Procedure, which grants high courts the power to revise cases decided by subordinate courts where no appeal lies against the decision. Article 227 of the Constitution of India provides the high courts with the power of superintendence over all courts and tribunals within its jurisdiction. Now, what can be reviewed? Number one is jurisdictional errors. In the case of Chogle versus Maruti Hari Jadhav, reported in AIR 1966, Supreme Court 153, the court emphasized that jurisdictional errors are examining whether the subordinate court exercised jurisdiction not vested in it by law, failed to exercise vested jurisdiction, or acted illegally or with material irregularity in exercising its jurisdiction. In Pandurang Dondi is a case where there are primarily what could be the grounds for revision has been stated. What are the material irregularities is the second point. Significant procedural mistakes affecting the outcome of the case. In Rajendra Kumar versus Rambai, reported in 2003, 1 Supreme Court cases, page 688, the case highlighted that material irregularities justify the exercise of revisional jurisdiction. Third is lack of jurisdiction when the court that passed the decree or order had no legal authority to do so. In the case of Amritlal B. Shah versus Reshma B. Shah, reported in 2011, 3 SAC, page 98, the court discussed the High Court's revisional power in cases where the subordinate court lacked jurisdiction. What could be the grounds of revision? Number one, when there is incorrect application of law by the subordinate court, or the subordinate court misinterprets or misapplies legal principles. In the case of Achyutananda Baidya versus Prafulya Kumar Gain, reported in 1997, 5 SEC, page 76, the Supreme Court held that incorrect application of law is valid ground for revision. Second ground could be absence of evidence when the court's decision is not supported by adequate evidence. In the case of Harishankar versus Rao Girdhari Lal Chaudhary, reported in AIR 1963, Supreme Court 698, in that the court highlighted the necessity of sufficient evidence to support the findings of the lower court. Third ground could be miscarriage of justice when the judgment results in an unjust outcome. In the case of Kishore Samrite versus State of Uttar Pradesh, reported in 2013 to SEC, page 398, the court emphasized the revisional court's role in correcting the miscarriages of justice. So what is the jurisdiction and limits of revision? The High Court's authority is revisionary power is vested in the High Court, ensuring that supervisory function is exercised by a higher judicial authority to maintain correct application of law and procedure in subordinate courts. Power given under Article 227 of Constitution of India and Section 115 of Civil Procedure Code. Scope of review, the revision is confined to checking jurisdictional errors and does not involve a rehearing of the case on its merits. The High Court does not reassess evidence or reevaluate the case's merits. New evidence, generally the revision court does not entertain new evidence. It focuses on the records and proceedings of the subordinate court to identify and correct jurisdiction or procedural errors. When there is gross injustice, instances where the decision results in a miscarriage of justice. Lack of jurisdiction, when the court that passed the decree or order had no legal authority to do so. Findings of fact, High Courts generally do not interfere with the findings of fact unless there is a clear error. When there are concurrent findings, when both the trial court and appellate court have the same finding, revision is rarely entertained. But it is not so in every case. Even if there are concurrent findings, the High Court, when finds that there is miscarriage of justice, the court lacked jurisdiction, or there is a scope of review in the case, then definitely, even if there is concurrent findings, the High Court can definitely interfere under the revisional jurisdiction. There can be no reappreciation of evidence. Revision does not involve reassessment of evidence or re-hearing of the case on merits. So whatever the evidence which has been assessed or the findings which the lower court has based upon, that cannot be reappreciated by the High Court under the revisional jurisdiction. Then there are procedural constraints. The High Court must act within the procedural confines of Section 150 of CPC. Revision is generally not available if there is an adequate alternative remedy. Next slide, please. Now, what is the procedure for filing a revision petition? The revision petition must be filed in the High Court with jurisdiction over the subordinate court that had issued the original order. What is the time frame? The petition should be filed within the prescribed limitation periods, typically 90 days from the date of the decree or order of subordinate court. Also, if there is a delay, sufficient cause need to be shown to the court for delay in preferring or filing the revision petition, which the court in its discretion can condone. What could be the format? The petition should adhere to the format prescribed by the court, detailing the grounds for revision and supported by relevant documents and affidavits. The hearing of the petition takes place and the court examines the records of the lower court for any jurisdictional errors or significant procedural irregularities. What are the key components of a revision petition? Next slide, please. Title and jurisdiction. The petition clearly must state the title of the petition and the jurisdiction of the court. Case information, mention the case number, date of the order, and a brief summary of the order being challenged. Party details, provide complete details of the petitioner and the respondent, including names, addresses, and relevant identification details and grounds for revision. That is the specific grounds for seeking a revision, such as jurisdictional errors, procedural irregularities, or illegalities. What are the tips for drafting revision petition? Be precise and concise. Next slide, please. Yeah. Ensure that the petition is clear and to the point, avoiding unnecessary details or repetition. Follow legal requirements, adhere to legal requirements and formats as specified in the CPC and relevant court rules. Attach all relevant documents, ensure all supporting documents and is certified and attached to this to strengthen your petition. Double check the details. Verify the details which you have mentioned as regards the parties, the order, to avoid any clerical errors that could delay the process. What are the don'ts of drafting a revision petition? Don't reiterate arguments from the original petition. Repeating the same arguments already considered by the court does not provide new grounds for revision. However, if certain grounds have wrongly considered by the lower court, definitely one needs to reiterate those arguments in the original petition. Supposingly, a court which did not have the jurisdiction has considered a judgment or considered a provision of law which has wrongly been interpreted by the court, and such argument was made before that lower court, that argument can definitely be reiterated in the original petition for revision. Don't ignore the procedural requirements. Failure to comply with procedural rules can result in dismissal, as has been said already. Don't misinterpret facts. Any misrepresentation or exaggeration of facts can harm the credibility of the petition. One must be very careful while putting facts on in any petition. If there is a misrepresentation, that is something which is not factually correct, something you are misrepresenting in the petition, that could lead to dismissal, because the court feels that the litigant who has misrepresented before the court does not requires court sympathy, and therefore no order in favor of that petitioner would be passed. On the contrary, if you misrepresent or you suppress certain facts from the court can impose costs along with the dismissal of your petition. So one has to be very careful, and no misrepresentation or exaggeration of facts should be done in your petition. Don't overlook court's guidelines on formatting. Incorrect formatting can result in procedure delays. I have already shown as to what is the format of the petition, and therefore one needs to adhere to such format always while filing a petition. That is, name of the court, the title of the court. Next slide, please. This is the format. Name of the court where the petition is being filed. Then the parties, name of the petitioner, name of the respondent. Then the provision under which you are filing the revision petition, and then the grounds as to how the impugned order or the order passed by the lower court, which is under challenge, is erroneous. So you have to specify the grounds as to what is the jurisdictional error committed by that court, what is the illegality committed by that court, irregularity committed by that court, or any other substantive error of law or procedure which has been committed, and because of which you are before the higher court, before the high court under this revision. Then you have to definitely make a prayer. The format is that the petitioner submits that the errors in the impugned order have resulted in a miscarriage of justice and warrant revision by the Honorable Court under its supervisory jurisdiction. Then the present revision petitions filed is within the statutory period of limitation as prescribed under the law, that the petitioner seeks revision of the order dated so-and-so of the lower court so-and-so, and prays that the same may kindly be revised and recalled in the interest of justice, and the petitioner craves leave to add, alter, or modify the grounds of this petition, or to adduce additional evidence if and when necessary. Then the prayer clause, you have to mention as to number one, the prayer would be allow this revision petition and set aside the order dated so-and-so passed by the lower court or a tribunal, pass any other order that this honorable court deems fit and proper in circumstances of the case, or grant any other relief that this court deems fit and proper in the interest of justice. Then you have to mention the verification clause. List of enclosures, definitely the certified copy of the order passed by the lower court, and the copies of the supporting documents, if any, or any evidence which you are relying on while challenging the order of the lower court. Now, what are the writ petitions and public interest litigation? The legal framework, writ petitions and public interest litigation serve as powerful tools to safeguard fundamental rights, enforce legal duties, and address broader public issues. These mechanisms are integral to the country's judicial system, allowing individuals and groups to seek judicial intervention when their rights or public interests are at stake. Both writ petition and PILs play crucial roles in promoting justice and protecting the rights of citizens within the Indian legal landscape. So what are the constitutional provisions under which the writ petitions or PILs can be filed? Article 32 empowers the Supreme Court to issue writs for enforcement of fundamental rights. Article 226 empowers the High Court to issue writs not only for the enforcement of fundamental rights, but for any other purpose. That means it can also be used for enforcement of your legal rights. Article 227 grants the High Court the power of superintendence over all courts and tribunals within their jurisdiction, ensuring that lower courts function within the law and without exceeding their jurisdiction. What are the types of writs? Next slide, please. Habeas corpus. You shall have the body used to bring a person before the court to ensure their detention is not unlawful or to release a person who has been detained unlawfully. In the case of Sunil Batra versus Delhi administration reported in AIR 1978, Supreme Court 1975, the Supreme Court emphasized the importance of the writ of habeas corpus in safeguarding individual liberty. The other writ the High Court can issue or the Supreme Court can issue is mandamus. We command directs a public authority to perform its duty. In the case of Bharat Singh versus State of Haryana, reported in 1988, 4 SCC, page 534, mandamus was issued to enforce a public duty. Next is prohibition to forbid issued by higher court to a lower court or tribunal, prohibiting it from exceeding its jurisdiction. In the case of East India Commercial Company Limited versus Collector of Customs, reported in AIR 1962, Supreme Court, page 1893, the Supreme Court discussed the scope of the writ of prohibition in controlling subordinate courts. Certiorari, to be certified, to quash the order of a lower court or tribunal which has acted without jurisdiction or in violation of the principles of natural justice. In the case of Hari Vishnu Kamath versus Ahmad Ishaq, reported in AIR 1955 Supreme Court, page 233, the Supreme Court outlined the grounds on which certiorari can be issued. Quo warranto, by what authority? To challenge the legality of a person's claim to a public office. In the case of the University of Mysore versus G.D. Govinda Rao, reported in AIR 1965 Supreme Court, page 491, the Supreme Court held that quo warranto can be issued to prevent assumption of a public office. What is the procedure for filing a writ petition? First of all, you have to determine what is the appropriate writ that needs to be filed in the facts of your case. I've mentioned 5 writs already. So appropriate writ has to be determined. Then you draft the petition. What is the content requirements? Facts concisely outline the factual background. Legal grounds state the legal basis for the writ, and the relief sought specify the relief or order sought from the court. Facts, first of all, you have to, whenever there is any petition which is required to be filed, firstly, you prepare a list of events, that is, dates and events. What has happened from the beginning till the end, till the time you're filing the writ petition, needs to be outlined in your petition. That is the date of events, wherein you mention as to what event has happened on a particular date and how you are aggrieved or how your rights or fundamental rights or legal rights have been infringed. And why you are before this court by filing the petition. So a synopsis or a list of events needs to be prepared along with your documents, whatever the facts are of your case, concisely outlining the factual background. Thereafter, affidavit in support, prepare an affidavit verifying the facts stated in the petition. Ensure it is signed and sworn before a notary or an authorized officer. Documents and exhibit attached relevant documents, evidence, and exhibits that substantiate the petition. The documents are attached in the factual manner. First of all, whatever facts you have mentioned, whatever facts are there in your petition, you have to annex the documents accordingly. Like if a fact is mentioned or event is mentioned and a document has taken place or some authority has issued a document against you on that particular date, then you have to annex that document along with that fact. Then how the legal representation has to be done: draft, file, and argue the petition. Submit the petition and documents at the appropriate court, High Court or the Supreme Court. Jurisdiction consideration: ensure the petition is filed in the court with proper jurisdiction, that is under Article 226, 227 or 32. The court fees has to be attached. The requisite court fees is there, which is to be attached with the petition. Serve the notice of the petition to the respondent or opposing party as per procedural requirements. There are different procedures being followed by different high courts. In the High Court at Bombay High Court Bombay High Court is following a procedure where after filing the petition, the notices are issued automatically through the respondents. Wherein in the High Court of Gujarat, the notices are issued after hearing the petition by the court. And if the court finds that the court requires to interfere in the case, then the notices are issued to the respondents asking for their response. What are the tips for drafting a petition? There has to be clarity and precision. Relevant sections have to be mentioned. If there is a service matter, you have to mention that there is infringement of Article 12, Article 14, Article 16. So accordingly, if there is any other provision of law which is required, you have to mention the provisions of law accordingly in the heading of the petition. In the case of Maneka Gandhi versus Union of India, reported in AIR 1978, Supreme Court, page 597, the Supreme Court emphasized that Article 21 guarantees procedural fairness, requiring clear and precise articulation of rights. Also, it has emphasized the importance of clarity in the prayer for relief to ensure enforceability and specificity of judicial orders. Further, in the case of A.K. Gopalan versus State of Madras, which is reported in AIR 1950, Supreme Court, page 27, the court underscores the importance of adhering to procedural rules for effective enforcement of fundamental rights. In the case of Keshwanand Bharti and State of Kerala, reported in 1973, 4 Supreme Court cases, page 225, the court highlights the necessity of clearly identifying parties to ensure proper representation and adherence to procedural fairness. Also, it reaffirmed the court's role in protecting fundamental rights and upholding the constitutional validity of laws. It has also stressed the significance of supporting documents and evidence in substantiate claims and uphold the judicial review. What are the don'ts of drafting a writ petition? Don't be vague or ambiguous. Clearly state the facts, grounds, and relief sought to avoid dismissal on grounds of ambiguity. Don't mix up causes of action. Separate distinct causes of action into different paragraphs or sections for clarify and specificity. There could be different causes which has compelled you to file a petition, but it need not be mixed while you are drafting the petition. The causes have to be mentioned distinctly in your petition in different paragraphs, and be careful that you don't mix up the causes of action. Don't ignore procedural rules. Adhere strictly to the procedural rules governing writ petitions in your jurisdiction to prevent rejection. Don't overlook jurisdictional issues. Clearly establish the jurisdiction of the court or tribunal where the writ is being filed to avoid jurisdictional challenges. For example, if there is a departmental inquiry which has taken place in the state of Maharashtra, then the writ petition is required to be filed in the Bombay High Court and not Gujarat High Court, because the entire procedural aspect of the inquiry has taken place in the in the jurisdiction of the Bombay High Court and not in the Gujarat High Court. And therefore, any court which is considering the issues, the writ petition, would necessarily be looking into the evidences which has taken place or which has been materially involved in the case, in the events which had taken place in the state of Maharashtra. So that jurisdictional issues must be, first of all, must be found as to which is the court which has the jurisdiction to deal with your case. Don't omit essential facts or documents. Include all relevant facts and documents to substantiate your claims, as unsupported claims can be dismissed. If your claim or your petition is not supported by relevant documents, then necessarily the court would not entertain your petition and would dismiss the matter as there are no documents supporting the facts mentioned in the petition. Don't make unsubstituted allegations. Support allegations with evidence or legal arguments to enhance the petition's credibility. Whatever you are stating in the petition must be supported with the evidence or with the legal arguments. Supposingly your right has been infringed, that means a legal argument is necessitated, because under the law, this is your legal right under the provision in a particular provision or under the act or under any law which has been enunciated by the decisions of the court. Your legal argument is based on that provision of law or the judgment. So that has to be clearly substantiated with your allegations. Don't neglect to cite relevant case laws and statutes. Generally, the drafting procedure is you never cite a case law in the draft of the petition. However, the trend is now to make it convenient for the court. The citation is being mentioned in the draft itself. But while arguing the petition, you can be ready with all the judgments which are supporting your case, and you can only mention the citations or relevant paragraphs in your petition, or you can attach the judgments along with the petition to facilitate the court to have gone through the same at the time of hearing of your petition. Don't forget to proofread and edit. Ensure the petition is free from grammatical errors, typographical errors, and inconsistencies to maintain professionalism and clarity. A lot of petitions are not entertained by the court because there are a lot of grammatical errors, there are a lot of typographical errors, the facts are not pleaded properly, there are inconsistency, and that would give a bad appearance on the part of any petitioner or the advocate before the court that there is no clarity in the language, and therefore you must be careful to proofread and edit your petition before it is filed before the court of law. What is a public interest litigation? Public interest litigation is designed to promote and protect the public interest by addressing issues such as environmental protection, human rights violations, and other matters affecting the community. It democratizes access to justice, enabling individuals, NGOs, and social activists to seek judicial intervention for the greater good. What is the legal framework? PILs can be filed under Article 32 in the Supreme Court for fundamental rights enforcement and under Article 226 in the High Court for broader issues, including legal rights beyond fundamental rights. Article 227 provides High Courts with superintendent's power over lower courts and tribunals. What could be the grounds for filing? PILs can be filed for violations of fundamental rights, environmental protection, human rights violation, and other matters affecting public health and safety. Next slide, please. What is the procedure for filing a PIL? Identify the issue, ensure the issue affects the public interest and not just the private interest. Drafting the petition include details of the petitioner, respondent, facts of the case, grounds for filing and relief sought. Filing, submit the petition along with supporting documents and affidavits. The court may issue notice, call for records, and hear arguments. It may also appoint commissions or experts to investigate and report on the matter. Identify the public interest issue. Clearly identify and articulate the issue that affects the public at large or a specific section of the society. Gather sufficient information. Next slide, please. Sufficient information and evidence. Conduct thorough research and gather credible evidence to support your claims. Select the right forum. Choose the appropriate court or tribunal with jurisdiction over the matter. Parties and standing. Ensure that the petitioner has standing to file the PIL, typically as concerned citizen or an affected group. Drafting clarity and precision. Be clear and precise in stating facts, grounds, and relief sought. Refer to specific instances and cases where the rights of individuals or groups are affected by the issue at hand. Public interest element. Emphasize the broader societal impact and the necessity for judicial intervention in the public interest. In MC Mehta versus Union of India, the Supreme Court intervened in environmental PILs to safeguard public health and ecological balance. Compliance with court rules. Adhere to procedural rules and format requirements prescribed by the court where the PIL is filed. Refer to specific rules under Supreme Court rules or the High Court rules governing PILs. Seeking appropriate relief. Clearly specify the relief sought, whether it's direction to the government to be taken to take action, enforcement of existing laws, or policy changes. Don't file frivolous PILs. Don't overlook procedural requirements. Don't make personal allegations. Don't misrepresent facts or evidence. Don't ignore alternative remedies. Don't violate court etiquette. Maintain decorum and respect for the court in your pleadings and arguments while you're representing in the court. Don't ignore the implications of judicial pronouncements. Stay informed about recent judicial pronouncement and precedents relevant to the subject matter of the PIL. Don't lose sight of public interest. Ensure that primary focus remains on the public interest aspect of the PIL rather than individual grievances and interests. Now, how are we drafting a writ petition? Drafting a writ petition requires a thorough understanding of the legal framework, precise articulation of facts, and clear presentation of legal grounds. This guide provides a detailed overview of the steps involved in drafting a writ petition, ensuring that it is comprehensive and well structured. A writ petition is a formal request to the court for an extraordinary remedy, typically used to challenge the government actions or protect fundamental rights. What are the components of a writ petition? Title, cause title, the formal heading of the petition, including court name, case number, and parties involved. A brief statement of the petition, purpose and constitutional basis. A detailed narrative of events leading to the petition and grounds for filing, that is, legal arguments supporting the petition, citing relevant laws and precedents. You have to mention the title, cause title, mention the name of the court, that is in the High Court of Gujarat, state the type of writ petition, include the names and addresses of the petitioner and the respondents, then briefly state the purpose of the writ petition, cite the constitutional provisions under which the petition is being filed, like Article 32, 226, or 227. Provide a sample format showing the correct layout. I have provided a sample format already. Have a detailed narrative. Provide a comprehensive account of the events leading to the filing of writ petition. Include all relevant dates, actions, and parties involved. Present the facts in a clear chronological sequence to help the court understand the progression of events. Focus on facts that are directly related to the legal issues at hand, avoiding extraneous details that may distract from the main arguments. Reference any documents, correspondence, or other evidence that supports the factual claims made in the petition. What is the legal basis? What could be the grounds for filing of the petition? Number one is the legal basis. List the specific legal grounds on which the writ is being sought. Reference relevant constitutional articles, statutes, and legal principles. Then, case law, cite precedents and relevant case laws that support your arguments. Explain how these cases apply to current situation. Third is constitutional rights. Clearly articulate how the respondent's actions have violated the petitioner's constitutional or fundamental rights. Then fourth is logical arguments. Present each ground in a clear, logical manner, explaining how the facts of the case relate to the legal principles being invoked. Relief sought and interim relief. Clearly state the specific orders or actions being requested from the court. This may include issuing writ of mandamus, certiorari, or other appropriate remedies. Be precise in describing the desired outcome and any specific directions you want the court to give to the respondents. It is seen that every case, the court first of all reads the relief. So it is very important that your relief or prayer is drafted well so that the court understand as to what relief you are seeking from the court. If your relief is vague or relief is not appropriate, which the court grants, the court may dismiss the petition in limine. So therefore, one has to be very careful while drafting the relief which you are seeking from the court. Also, what is the interim relief you are seeking? If immediate temporary relief is required, specify the interim orders being sought. Justify the need of interim relief based on urgency and potential harm. This may include a request to stay certain actions or maintain the status quo until the case is fully heard. Additional orders include a request for any other orders that the court may deem fit and proper in the interest of justice. This allows for flexibility in the court's decision-making process. Then, of course, verification. The petitioner must verify the contents of the petition, affirming that the facts stated are true and correct to the best of his knowledge and belief. Affidavit includes sworn statements that support the claims made in the petition, providing additional credibility to the case. Annexures attach all relevant documents and evidence supporting the claims made in the petition, properly indexed and referenced. Then this is a format, sample format, which says that in the High Court of Gujarat at Ahmedabad, writ petition civil number dash of 2024 in the matter of name of the petitioner, occupation, age, address, then versus name of the respondent number 1, designation, address, name of respondent number 2, designation, address, then petition under Article 226, 227, 32 of the Constitution of India, then the formal way of addressing the court, then most respectfully showed that the petitioner is resident or and is engaged in so and so. The petitioner is a citizen of India and the following rights have been infringed, and the petitioner has a right to challenge the action of the respondent so and so. That petitioner is the aggrieved from the action or inaction of the respondent, which has resulted into so and so harm or violation of his rights. That on so and so date, the respondent, what action or inaction has been done by the respondent, you have to mention it. Then the petitioner has approached the respondent on multiple occasions, but no relief has been provided. You also show that you have approached the respondent, but to of no avail, that there has been no relief given by the respondent. Then the grounds, because the respondent action is arbitrary, unreasonable, and violative of Article 14 of the Constitution of India, because the fundamental rights under Article 21 has been infringed upon due to the respondent's action, because the respondent has failed to discharge its statutory duties, thereby causing grave injustice to the petitioner. Then, of course, the relief, issue a writ of mandamus directing the respondent to take so and so action, a writ of certiorari quashing the impugned order dated so and so, pass any other order that the Honorable Court may deem fit and proper. Then interim relief, stay the operation of the impugned order dated so and so, direct the respondents to maintain status quo with respect to so and so issue. That can be your interim relief. Then, of course, the verification clause, name of the petitioner above name, hereby verify that the contents of the paragraph so and so are true and correct to my knowledge and belief, verified at so and so. Then the annexures have to be that the copy of the impugned order dated, then the copy of the correspondence so and so. Whatever the annexures are, you have to produce it along with your petitions. Thank you very much. Any questions?
Participants can unmute themselves and ask the question one by one. Yes, anyone wants to ask a question?
So, good evening, sir. I have two questions. May I ask?
Please go ahead.
Sir, is there any limitation for filing writ petition, sir? That is my first question.
Is there any invitation?
Limitation for filing.
Yes. Limitation. What is the next question?
The next question is, if I am preferring the review application and if the same has been rejected by the court, can I file the appeal against the original order or decree?
Number one, the question is the writ petition has to be filed within the reasonable period. There is no limitation as such, but the reasonable period has to be there in filing of the writ petition. You cannot come to the court after about 5 years or after about 4 years without there being a reasonable ground to prefer the writ petition. So there is no limitation prescribed for filing the writ petition, but there has to be a reasonable period within which you can file the writ petition before the High Court or the Supreme Court. It may not happen that some cause of action which has arisen in 2020, you are coming before the court in 2024. Usually what happens is that people keep on preferring or making representation to the authorities and do not choose to come before the court. That also is harmful because whenever there is an infringement of right, you should immediately approach the court of law, and the earlier the better. But there is no limitation as such in preferring the writ petition. The second question you asked was that if you have your review is decided against you or is rejected, whether you can file. Definitely, if a review petition is filed before the High Court and it is rejected, you can certainly approach the higher forum, that is the Supreme Court, against that order of review. If a single judge, see, in the hierarchy of courts, if a review petition has been decided against you or is rejected, you can certainly prefer the appeal before the higher forum in whatever ways it is available to you.
Yes, sir. Thank you, sir.
Thank you.
Sir, can I ask one question?
Please.
Sir, our Gujarat High Court procedure, appeal from order and SCA, both are arising of civil court. So when may be applicable appeal from order and SCA under 227?
There are the appeal from order. There are
40 order 40.
there are orders which can be filed where AO can be filed. So AO's jurisdiction is very different from the writ jurisdiction what you are asking for. So AO's there are specific orders which can be challenged before the High Court under the purview of AO. So AO has nothing to do with the jurisdiction what High Court has under Article 226 of the Constitution. So there are orders which are prescribed. So you can go through it. That what are the orders which can be challenged before the High Court under the AO jurisdiction.
Good evening, sir.
Good evening.
It was an amazing session. May I ask one question?
Please.
Sir, the Article 226, at last, but for any other purpose, like we can file a writ petition under Article 226.
Any other purpose is if there is an infringement of legal right. If you have any legal right, you see there are fundamental rights which are listed in the Constitution. But if there is any legal right that is for all other purposes, you can file a writ petition before the High Court.
Okay, it's like it has wider jurisdiction than Supreme Court.
Yes.
Okay, sir. Thank you, sir.
Hello. Good evening, sir.
Good evening.
Sir, I am Rajnikant.
Yes. Go ahead.
What is the court fee for PIL and writ petition, sir?
See, writ petitions, the court fees depends on the parties. Like if there are 10 respondents, the court fees would be 50 rupees or 30 rupees. So the court fees is not the same as we file in the appeals. So in the writ petition, it is not as much. It is about 50 rupees, 100 rupees, depending on the number of parties you have. So the court fees in writ petition is very reasonable amount.
Regarding PIL,
Regarding
PIL petition,
PIL, same thing, same thing.
same. Thank you.
I think there is no question, sir.
Sir,
No?
I
Yes,
want to ask. Yes, I want to ask you a quick question. That, sir, what are the best practices to do an offline research to find any, relevant citations or case laws without doing any online research, purely offline? What are the best practices?
Best practices is you go to the library and, first of all, you have to know as to what is the point in issue. There is a proposition of law. Now, proposition of law, usually what you have to find is you can go to the library where there are digests available, right? Wherein you can find what are the propositions. There are indexes given. In those, you can find out what is the proposition of law and what are the judgments available on that proposition of law. In the library, before some years, there was nothing available to us in the form of online research method. So we were going to the library. We were looking at the digests available. There were some books available wherein the propositions of on particular proposition of law, the judgments were available, and then we could find out what the latest law available on the point is.
Thank you so much for such an insightful response, sir. Really appreciate it.
Thank you.
Yes, sir. My name is Kishore Kumar Kankavanala.
Go ahead.
Sir, there is one question is pending in chat box, sir, by advocate side. I request you kindly to respond this question also, because he is unable to unmute his this thing.
Not able to understand what you're saying. Yeah, my question is, can we file a writ petition to town-bound city civil court matter for valid purpose where opponents are not appearing and taking a judgment for their own whims? Can we file writ petition? Yes, you can. You see, you can file a writ petition if before the court, but this kind of issues are generally not taken up by the court. You have to approach the same court because there is a long pendency which is there in every court. So generally, the higher court would not interfere wherein the adjournments are granted, because the adjournments is the domain of that particular court. Why the adjournments are granted, the court generally does not question. But at times, the court, when sees that a particular issue is not decided by the court in a reasonable time, the court may give a time-bound frame to the lower court that you please finish the case in 1 year or 2 years. But that would be in rare circumstances. Usually what happens is you challenge the action of the court under the supervisory jurisdiction, and the court feels that this court is not dealing with the matter properly. Then court may say, without giving any relief or without taking up the case on merits, give a direction to the court to decide the case in a time-bound manner.
Thank you, sir. Thank you very much, sir.
हेलो सर जैसे आपने बोला था कि जब जजमेंट डेप्टर में फुल डिटेल्स देनी पड़ती है एड्रेस की, तो उस केस में क्या ये एग्जीक्यूशन पेटिशन के समय पर क्या इसमें पूरा केस और एग्जीक्यूशन पेटिशन सिर्फ मोबाइल नंबर के थ्रू नहीं चल सकता?
मोबाइल नंबर भी देते हैं आजकल पिटिशन।
ओनली ओनली मोबाइल नंबर?
नहीं, ओनली मोबाइल नंबर पे नहीं होता, बिकॉज ओनली मोबाइल नंबर से कैसे पता लगेगा कि कौन क्या है। एग्जीक्यूशन पिटिशन क्या होती है? एनफोर्समेंट ऑफ डिक्री। तो डिक्री में ऑलरेडी उस जजमेंट लेटर का एड्रेस होता है, उसका वेयर अबाउट्स होते हैं। कोई भी डिक्री या ऑर्डर ऑफ द कोर्ट विदाउट एड्रेस ऑफ द अदर साइड इज नॉट देयर।
सर जैसे एक और चीज है सर, जैसे 138 के केसेस होते हैं उसमें जैसे अगर 4 साल भी लग गया और फिर उसमें कुछ होता है कि अभी भी जो अमाउंट है बच जाता है, तो उसमें एग्जीक्यूशन पेटिशन डाली जाती है। अब वो एग्जीक्यूशन पेटिशन कंप्लीट होने में या उसे रिजॉल्व होने में कितना टाइम लगता है? कोई डेडलाइन होती है उसमें?
कोई डेडलाइन नहीं होती, डिपेंड्स। एग्जीक्यूशन इज जनरली एनफोर्समेंट ऑफ योर राइट, इट इज इमीडिएट रेमेडी, उसमें डेडलाइन नहीं होती। लेकिन अगर एग्जीक्यूशन पिटिशन का ऑर्डर एग्जीक्यूट करने लगती है कोर्ट, तो इट इज very quick relief, and if anything is available, the court can order attachment of the property, arrest of the person of the judgment debtor. So it's a very quick relief. उसमें जितना भी पीरियड है, it's very short period within which you will get the relief.
कोई टाइमलाइन नहीं है सर? क्योंकि
टाइमलाइन नहीं होती, बट इट्स अ क्विक रिलीफ, जिसमें कोई टाइमलाइन ऐसा नहीं होता, बट इट्स अ क्विक रिलीफ बाय द कोर्ट, wherein a person can be arrested if he is not coming to the court, is not enforcing the decree, or is not meeting with the obligation which is provided in the decree.
सर आपने बोला था कि रिलीफ मेंशन करो, पर ये रिलीफ तो डिक्री में ऑलरेडी मेंशन होते हैं।
हाँ, तो वही रिलीफ को आपने मेंशन करना है। जो कोर्ट रिलीफ होती है कि भाई ये रिलीफ दिया गया है मुझे कोर्ट से, तो ये वो जो जजमेंट डेटर है वो ये he has failed to give that what is provided, वो ऑब्लिगेशन जो उसको बोली है कोर्ट ने और उसको पेमेंट करने के लिए बोला है वो नहीं कर रहा, तो वही रिलीफ है।
सर एक और चीज है कि आपने बोला उसमें कुछ कम ज्यादा नहीं हो सकता, जैसा डिक्री हुआ है वैसे ही जाएगा। क्या उसमें इंटरेस्ट नहीं लगाया जा सकता है, जैसे जितना टाइम पीरियड से पेंडिंग रहा है?
जो इंटरेस्ट लगाया जाता है वो यूजुअली कोर्ट्स आजकल इंटरेस्ट देती हैं टिल रियलाइजेशन, मतलब जब तक आपको मिलेगा तब तक इंटरेस्ट चढ़ता रहेगा। तो वो जब तक आपको मिलेगा नहीं तब तक इंटरेस्ट उसका बनता रहेगा।
तो वो सर ऑटोमेटिकली होता है, उसमें एग्जीक्यूशन में मेंशन करने का जरूरत नहीं होता है इसमें?
टिल रियलाइजेशन है तो वो ऑटोमेटिकली चलता रहेगा, जो आपका ब्याज है वो चढ़ता रहेगा।
सर मिनिमम उसमें क्या इंटरेस्ट रेट बताया है आपने, जैसे क्या होता है मिनिमम इंटरेस्ट रेट?
वो डिफरेंट इंटरेस्ट रेट्स होते हैं। ये आपके क्वेश्चंस बहुत जो आज के सेशन से बियॉन्ड है।
ओके,
आई एम सॉरी टू से, बट ये चीजें तो इस सेशन के लिए नहीं है। प्लीज यू हैव टू बी वेरी स्पेसिफिक टू दिस सेशन।
ओके सर, थैंक यू वेरी मच।
थैंक यू।
Good evening, sir.
Good evening.
Sir, am I audible?
Yes, go ahead.
Sir, I'm a law student, and I often face difficulty in revision petition and in appeal. So, sir, could you please simplify it? Like, what is the difference between these two?
I've already said it. If you have heard my this thing, the differences already has been stated. Under revision, under section 115, the jurisdiction of the High Court is limited to correct the jurisdictional error if there is any court which has gone beyond its jurisdiction. So I've already said very specifically as to what is the jurisdiction under 115 of the High Court under revision, and what is the jurisdiction of the High Court under the writ jurisdiction under 226 or 227. So if you have heard this thing, you can go to YouTube again and listen to my session again.
So, means I'm asking the difference between appeal and revision. So, like, what are the grounds there?
Yes, appeal is where the court hears the matter, rehears the matter completely. It can reappreciate the evidence. It can also reassess the evidence. So appeal is the continuity of the proceeding which has happened in the lower court. But again, this question is beyond this session. You're asking something which is not which was not said in this session. So appeal, the court has wide power. It can reassess the evidence. It can also look into the jurisdiction. And it is the continuous proceeding of the lower court proceedings,
Okay, sir. Thank you.
unlike the revisional jurisdiction.
Okay, sir.
Sir,
Can-
sir, after represent.
I think we have gone beyond our time limit. It is 8:15 already. Any quick question? One last question.
Yes. Can you explain the doctrine of latches, sir?
Latches, I've already said that the delay in latches has to be, very reasonable in filing of the writ petition. If it is beyond reasonable time, then the court is very, very strict in interfering with the case. There are numerous judgments on delay and latches by the Honorable Apex Court as well as of various high courts as to what is the reasonable period under which you can approach the High Court or the Supreme Court in exercising in their jurisdiction under 226, 227 or Article 30.
Okay. Thank you, sir.
Thank you.
I think all the questions are addressed, sir, perfectly. So shall I conclude this session with your permission?
Please.
Yeah, thank you, sir. I would like to conclude the session. Before I conclude, I'd like to extend a sincere vote of thanks to sir on behalf of everyone present here today. Our sincere appreciation for enlightening presence and enriching our event with your profound insights. We are truly honored to have the privilege of hosting you, and we look forward to future opportunities to benefit from your wisdom and guidance. Once again, thank you so much for an invaluable contribution to our today's session. Thank you, sir.
Thank you very much. It was indeed my pleasure to be part of this session today. Thank you very much.